I'd like to turn it over to Andrew. Andrew Lehmann is a staff attorney with the Houston Volunteer Lawyers Association that we all are familiar with. He's been the attorney in charge of the HVA's Veteran Legal Initiative for 6 years. This program conducts over 70 free legal clinics annually and advises or represents about 2,500 veterans a year. He attended law school at U of H, and prior to entering law school, he was a sergeant who served over 4 years in the Army as an M1 armored crewman, okay, including 2 combat tours in Iraq. So he is a veteran who's serving our veterans, and we're very happy to have him with us tonight. Thank you.
Well, thank you, Allison and Paul, for inviting me, and y'all can thank them later too if I'm any good. You can blame them if I'm not. That was all on them. I have to know who the Congress people are running because I'm going to blame them for everything in this presentation, so that's really important for me to keep track of whose fault it is this week. So what I'm going to talk about today is in two broad parts. We're going to talk about substantive VA benefits law. What are people talking about when they talk about VA benefits? What are people talking about when they say a backlog or claims and stuff like that? The second part is going to be about the pro bono work that Houston Volunteer Lawyers does, that we do out here in Tomball, that we do for our veterans to serve them and give back to our community. So we're going to start with VA benefits. I got some comics inserted in there. I don't have permission to use them, so I'm not going to talk about them on the voice recording, but they were just here to break up the monotony of PowerPoints. So we're going to start with the easy ones on benefits. And I define them as easy as being ones that don't usually create controversies that lawyers handle. These are ones where if you have served in the military and you have your discharge paperwork and an associated photo ID and you present yourself at the facility that can provide these services, they will give it to you. Educational benefits are the most commonly used ones. The big one are the GI Bill and the Hazelwood Act. GI Bill is the way that most veterans get their college paid for after service. It is relatively generous. It is relatively easy to get. It pays a portion for living expenses. It pays the tuition at your university at in-state rates. It will pay it for up to 4 years if you have enough time in service, and it will pay less if you have less than 4 years of service. The Hazelwood Act is something exclusive to Texas. Other states have similar programs. What it is a waiver of in-state tuition for service members after military service that have exhausted their GI Bill. It does not provide any living stipend or any book expenses or any other costs, but it waives in-state tuition at Texas universities. Both of these are transferable in some cases to spouses and to children. So even if somebody is not a veteran, if they are the spouse of a veteran, or in the Hazelwood Act's case, the child of a veteran, they may still be able to take advantage of these benefits. Housing benefits. The big one that most people use is the VA housing loan. What that is a piece of paper you fill out with your lender that says that they will guarantee the first $30,000 in mortgage. What it works as is it basically goes in lieu of a down payment. So if you're a veteran, you're purchasing a house, you don't have the down payment up front, they will guarantee $30,000 in mortgage. It will get you the rate that you would get if you made a $30,000 down payment.
I apologize for the early interruption, but before you leave the Hazelwood Act, which I'm not familiar with, is that applicable to advanced degrees in addition to undergraduate degrees?
It is.
Such as law school, medical school, those kinds of things as well?
I'll pay for my law school, so I hope so. Yes, and it is also for other kinds of trainings like vocational school, pilot school. It will pay for anything that will get you a better job. AC repair, any of those. For the GI Bill. For the Hazelwood Act, it has to be a Texas institution providing it. So, for example, if it's the University of Houston Law Center, Hazelwood Act would cover it. If it was, Joe's Pilot School, probably not.
Thank you.
What about voc rehab?
Vocational rehab is actually a different category because your eligibility for that is based on you have exhausted your educational benefits, and whatever profession you're in is not going to find you a job, and you apply for it and they will pay for it for you for a specific program catered to your needs and background. So that is different than the basic educational benefits because you're getting that through a transitional assistance program and not through the VA educational department. So they don't actually crosstalk very much. All they do is determine you cannot use the GI Bill, you cannot use the Hazelwood Act, you can't get a job, you may be eligible for vocational rehab. Where did I skip to on that one?
Medical.
Oh, okay. Sorry, I got thrown off already. So the most common homeownership purchase assistance is the second most common benefit that most veterans use. Homeless veterans and HUD-VASH, what that is there are housing vouchers available for veterans that are much easier to get than they are for non-veterans. They are not limited by number. They have people that will assist them with every step of it as long as they can produce a photo ID and proof that they served in the military. That will get them in transitional housing. There's no upfront expectation that they have gone through any sort of treatment program or that they're otherwise in a position to have housing to get that covered. And Allison brought up, for example, what the HBA does with the gift bags. There's a homeless shelter near downtown Houston where the old Sears used to be called Midtown Terrace. It's run by U.S. Vets. That's the one we partnership. We go there every month and we give them gifts at Christmas, so that's what the holiday bags are for. So they're mostly under the VASH program as transitional housing. So it's relatively quick to get. Eligibility for that is pretty wide open. There's occasionally funding issues with it, but here in Houston, at least, it hasn't affected us. There are some strings attached for the veterans, and that is why you will still see homeless veteran signs occasionally, because there are veterans that do not want to live with those conditions. In some cases, I understand it, but if they did want to get housing, it is available for almost all veterans. There's a program that the state of Texas runs called the Texas Land Board, which is its own strange thing, but it provides certain benefits to Texas veterans attempting to purchase large plots of land. They get a earlier chance to purchase them if the state has acquired them through foreclosure or some other process. I do not know why that benefit exists, and I've never been anyone who's used it, but now you know it exists. Medical benefits is the next most common one. For retirees, they are entitled to medical care through the VA for all things that can go wrong with them for the rest of their lives. For veterans that have service-connected disabilities that we'll be talking about later, they are entitled to health care if they are disabled enough or anything related to what their service-connected disability is. In addition to that, there's a need-based program that the VA does where people that don't have a lot of income can apply to say, I don't have another way of getting health care and I cannot afford it, and then the VA will give them health care. The threshold you have to be poor enough to get that changes every year, and the VA accepts people until they run out of resources. Locally, and for most VA facilities I'm aware of, they basically don't turn anyone away that applies for that unless they have another way of getting health care. That's one of the reasons the system is always burdened, is because they don't tend to say we can't help any more people. What veterans are not entitled to is everybody served is not entitled to free health care for life, which is sometimes a misconception of why so many veterans use the VA. It's because it is free. You can use it if you're a disabled veteran and you have private health insurance. They can bill your insurer for them. You can use them like a doctor's office. So some veterans choose to do that, or veterans that have multiple reasons to have VA service can use it like that. But it's not for all veterans, and if I walked in there right now and said, I want medical services, they would turn me away because I am not currently eligible. The final one is funeral services. If you are a veteran, they will provide you a plot and a respectful ceremony when you pass away. They will give you a color guard and a flag and a headstone, all of that no cost to the veteran. The only veteran's responsibility is to get the deceased veteran to the funeral home. There's a national cemetery very close to here. It's very nice. They've got plenty of space. That is where most of them get interned. There's some state cemeteries, none around the Houston area. There are more famous national cemeteries. Only Arlington is as space allows, facility. So if you want to get buried at Arlington, you have to apply and have a very good reason to do that. Yes, sir.
Is that in addition to any Social Security death benefits that they may be entitled to?
Yes, that is completely independent from it. And for low-income survivors, the VA will also do something similar to death beneficiaries to pay for certain of those expenses that come with it. But all of that is free to veterans, regardless of income, regardless of how long they served, what their character discharge is. That one is a wide open, respectful benefit that's available. Then we get to the hard ones. Service-connected disability compensation and veterans pension. I'm going to talk about veterans pension first. Those are the ones that involve all the bad stuff you hear about the VA that's not medical services. That involves veterans that have served and have a service-connected injury and want monthly compensation in the form of money from the VA. That is where almost all the legal work dealing with veterans comes on. We've been doing this for 60 years, and the number of people have come in and said, I have a legal issue related to one of these, I can count on 2 hands. And I can count on 2 hands the number of those I see every week. So this is where almost all the problems fall in. You're aware the other benefits exist. We don't know what to go into them because you're not going to get any legal issues that come with them in general. How do you know they're eligible for them is based on your characterization of discharge. So everybody that serves in the military is at some point discharged, or they're here and they're AWOL. And at the point of your discharge, you are given a characterization of your service. The most common one is honorable. This means you passed military. It does not mean you were good at it. It does not mean you did everything you were asked to do. It doesn't mean that you're very competent. It means that everything between the greatest hero we've ever had and the guy that barely skated by are all honorably discharged veterans. This is the broad category. A honorable discharge will get you eligibility for all the benefits we discussed. There's no higher level of discharge or special benefits you're available to. Then they come the other discharges. So there's 5 broad categories of those. Some of them are negative in characterization, some of them are not. But they've all, to get to any of those others, they've gone through an administrative process where there was significant shortcomings in their military service. So nobody comes to their end of their military service, says, give me my discharge paperwork, and gets handed a general discharge. Something happened before then to get there, and the service member knows what happened. Or they were AWOL. Well, then they know what happened too, so that doesn't count. The other 5 broad categories in decreasing how bad they are is general discharge, uncharacterized, other than honorable, bad conduct, and dishonorable. Each level as you go down requires more administrative and legal proceedings in the military that will take longer to get to. For example, dishonorable discharge will usually end after a court-martial, after you've gone through a lengthy trial procedure, and it will cut you off from all benefits forever, and it will also go into your criminal record. Where general discharge, you can be discharged general under honorable conditions, and that can just be administrative problems. For example, you can't pass the PT test, you can't keep physical fitness up, something that definitely would have plagued me if I had stayed in the military. So it's not necessarily saying you're a bad soldier, you did anything wrong, it just says we can't use you in your current shape. We're going to give you a general discharge. We're going to get you out before your contract is up, but we don't really dislike you, and you're still eligible for most benefits, but not for everything. The big one is where there's a hang-up is the GI Bill, honorable discharge only. So again, that's the one that veterans use the most. So if you get a general discharge and you want to use your GI Bill, that's when you're going to be coming to us for help with your discharge status.
So it can be changed after the fact?
Yeah, we're going to talk about that right now.
Oh.
How do you know what their discharge is and anything else about their military service? This is a DD-214. It is a document that everybody that gets out of the military now gets. Some version has existed of this since World War II. This is the 2000 version. So this will tell you everything you need to know about their military service to determine their eligibility for any of the benefits we're talking about, absent their military record. Eligibility will depend on length of service, whether they have wartime service or not, and I'll talk about why in a minute. And the characterization of service, this is where it'll say honorable or something else. And if it says something other than honorable, it will explain why down here. This is why we got them out of the military. Usually that's in shorthand military code, so nobody can read it without looking it up. But that will all be on the DD-214. Everybody that gets out has one of these. Again, no surprises for them why they're here or what their eligibility is. If they have one of these, we can figure it out. And they can get these at the regional office near downtown Houston or online, or order them from the personal records and get them within a few weeks at most. So there's no reason somebody shouldn't have one of those. How to upgrade a discharge. So what we do see is people that come in, they're looking for discharge upgrades, and they've been given something other than honorable discharge, and they want to upgrade that. Good news for them, the process for asking for it is not that complicated. There's two boards you can go to, and I will always confuse these two, so I just say the board, Discharge Review Board, and a Board of Correctional Military Records. Each service has a Discharge Review Board. If you feel that your discharge was done incorrectly, you can apply for them for an upgrade within 15 years. Burden is on you. You have to show they made an error in how they discharged you. They didn't follow the correct process of getting there. Or that you were treated differently than other similarly situated service members. So 3 DUIs in the month, 2 of them got Article 15s and extra duty, and you got discharged. So you have to show that they were treated differently than other people in the same situation you were. The Board of Correctional and Military Records can do whatever it wants. You don't have to prove anything. You don't have to show anything. You don't have to do anything within a timeline. All you have to do is convince them that for whatever reason, your discharge was inequitable. The Board of Correctional and Military Records is also the appeal board for the first board. So even if you get rejected by the first board, you can always go to the second board. There is a theoretical 3-year statute of limitations that the board has, as far as I'm aware, never not waived. So there is in theory a statute of limitations, but as far as I know, it's never been applied.
Who sits on those boards?
A bunch of retired military people or retired federal government people that love DC and love the government and love the military and don't want to hear anything bad about it. And that is why you have an approval rate of less than 10%. They're all retired sergeant majors and retired colonels that think the military never makes mistakes, and that is why you have a very low approval rate.
So not a board of their peers.
It is not a board of your peers. It is a board of strong institutionalists. But your approval rate is less than 10%, and based on the claims I've seen, I actually think that's very generous.
So you're saying there's a chance?
There is always a chance. It's not. There's a higher chance for certain things that change over time or policy changes. So a common one right now is there's 2 ones right now. One is that your discharge was a result of behavior you did that was a manifestation of a mental health problem that was undiagnosed and untreated. The other common one is that the policies changed about what you did wrong and you were discharged for something like homosexual conduct. Those are actually pretty easy to get approved right now. There's a lot of attention on them. You show them that's the reason that they were discharged. Those get approved at a pretty high rate. What we actually see more frequently, though, is that it was misconduct on behalf of the service member. It was your AWOL. It was your failed drug test. It was other performance or conduct issues that don't fit in that category. So those are rejected at a very high rate. The discharge review boards don't operate like any court system at all. There's some disadvantage. The discharge is presumed to be correct. They take that very seriously. They presume the government did what it was supposed to do. There's no benefit of a doubt, and all the evidence is on the veteran to provide. If they say something happened, then they have to prove it happened. The advantages are there's no opposing counsel, nobody standing on the other side arguing why you're a terrible soldier. You get to present your case one-sided. There's no rules of evidence. You can show them whatever you want, whatever you think they should consider. And it's equitable hearing, meaning that they don't have to follow the law to do it. They can do it if they think it's in the interest of the service and the interest of the veteran to upgrade the discharge. So this means you can use character witnesses and show them how your life has changed since your service, if it was an issue of character or conduct, to get an upgrade. So this is why your rejection rate actually improves over time, because the further away you get from it, assuming your biography is compelling enough, you can present a story that has nothing to do with what the military did wrong and say, I made these mistakes when I was younger, look what I've done with my life. And that's a much better chance than trying to convince a bunch of people that love the military that the military screwed up. Any questions about the discharges or characterization of discharge or anything like that?
Are there lawyers in DC who represent these applicants?
Yes, and they do it for free. There is a program of DC called the Pro Bono Consortium that handles these claims. All of them are in DC. At the initial application level, it's just a paperwork matter. The board hearings are optional, so you have to specifically request them. The veteran has to make a personal appearance for that, so they have to have it programmed in their mind when they apply that I'm going to pay for my own trip up to DC at some point to repeat it. Yes.
I have one question. So, like, what if I noticed that there wasn't a medical discharge listed there? So, like, what? I mean, is that?
That's honorable. Generally, it's considered honorable.
Honorable,
You'll be treated
okay.
as an honorable veteran if you got a medical discharge.
Okay.
Frequently, medical discharges are categorized as medical only if you're medically retired, but on the D214 it will still say honorable,
Okay.
and it will say the reason as medically retired.
Okay, cool, thanks.
Can you flip back to your slide that showed the different types of discharges? I have a comment and a couple of questions. And I'm sure you know this, but
Don't be that sure.
Frank and I were both judge advocates
Okay.
in the Air Force in the Vietnam War time.
Oh, what did I get wrong?
We know enough to be dangerous. But it's old news. So the bad conduct discharge and the dishonorable discharge
Yes.
are clearly and exclusively only court-martials. You can't get them any other way. There's two categories, administrative and court-martials. And those two categories, there's a wall between them.
They call them
So the bad
punitive.
conduct and the dishonorable, at least unless it's changed. The other discharges can in fact be given only administratively. Now, the one that was my comment. My question is, when I was around, there was never such thing as an uncharacterized discharge. Can you describe what that is? And one more comment that I know to be a fact. The other thing, with respect to the discharges, it varies service to service. There are specific rules under the Air Force and the Army, the Navy, and the Marines, and they have different internal rules. So what I am feeding to you, of course, was the Air Force dogma. But anyhow, I have never heard of an uncharacterized discharge, period. Can you explain what that is?
I think you think of it as an entry-level discharge.
As what?
Entry-level discharge. Or they may call something different. But basically, you showed up for training and they got your medical records back and they're like, oh, we shouldn't have taken you. And then they discharge you. If they don't blame you for getting your discharge wrong, it's considered uncharacterized. It's neither good nor negative, but it basically says, we mutually agreed before we got serious about this to part ways. That's the most common use from it. I've not seen it used in any other examples other than entry-level point where people have less than, I think 30 days service typically, so they show up for in-processing. They don't usually make it to a training unit and get pulled out for some reason. It also allows people who just don't mend from day one, they're crying for mom on the first night, like it's not going to work out. But we're not going to punish you for leaving, it would be a pain for both of us. We don't owe you anything though. That's why it's uncharacterized and not anything else, because there's no eligibility for anything.
And that was one of the differences between the Air Force and the Marines. We used to just let them go with those behavioral characteristics. The Marines would shoot them.
The bad conduct, I don't know if they did this when you were all in. I would only say the difference between the punitive discharge and the administrative discharges is they do accept something similar to a plea agreement now. I don't know if they did that when you all.
No, they do.
Okay.
They did then, but the plea agreement frequently moves it from a court-martial to an administrative discharge.
Well, it depends on
So
how bad
frequently
they
do that with officers, not enlisted people. Just at least that's my experience.
I have not. Okay, I don't recall if I've ever seen one that ended up pleading to bad conduct on that. Are you going to keep me honest this whole time? We're going to have trouble. And they've changed the name on one of these too for undesirable. I can't remember what undesirable used to be, but that is something else to always be aware of, is that people were discharged in 1970 and are talking to you now. There's been stuff that has changed that will not look like it makes sense. Did I answer your question?
You did. Thank you very much.
Please keep me honest. Give me any notes on the slides too. Again, I was definitely not a JAG. I didn't know what JAGs did until I got out of the military. So we're going to talk about VA pensions now. Moving on from discharges. So what a VA pension is designed to do is to supplement income for veterans that have no other resources. This is similar to supplemental security income, and it is your last-ditch resort to get money in your pocket so that you're not on the street. The broad eligibility categories for this is a wartime veteran, and you must be over 65 or permanently disabled and have limited or no income. Talk about each of those a little bit more. Wartime service is not service in a war, it is service during a war. For most of our history, since the 1950s, according to the Department of Veteran Affairs, we have been at war. We've been at war continuously since 1990. So that category covers a broad number of veterans. Basically, the only ones that don't fall that are ones that had the misfortune of serving in the 1980s. You must have 90 days of active service. If you served prior to 1980, after 1980, that changes to 24 months or whatever you were called for. So reservists are called for a year. That's good enough. If you sign a contract that was for 18 months and you did all 18 months, that's good enough. And, look, I'll pause here for a second. This is just emphasis on the wartime service does not mean war service. Pretty big difference.
That's funny.
Totally disabled for people under 65 means that it is not the result of your own misconduct and that you cannot get a job anymore, that you're unable to work. They'll take Social Security's determination for that. They'll also take nursing home or long-term care if that's where you are, or anything else that they consider disabled. This is the VA's determination of disabled. The definition is a little different than Social Security's. It's a little more broad than that, but you have to prove that you're currently disabled or over the age of 65. The government considers over 65 disabled. I don't know if any of you are offended by that, but that is their determination, not mine.
Is this where a lot of the PTSD that you're hearing all the time, where people are coming back and they just,
Nope.
that doesn't fall here?
That's going to be service-connected disability. This is nothing to do with your military service. The reason you're disabled is totally irrelevant to this concern. This is for people that have any disability, whether it has anything to do with the military service or not. So they could have gotten out of the military, clean as a whistle, walked their way off the post, got ran over by a car. They're eligible for a VA pension. What limited or no income means is about $1,000 a month. This changes annually by a small amount. It's designed to supplement your income up to $1,000 a month. So if you receive Social Security at $500 a month and you are eligible for the VA pension, you will get a total of $1,100 a month. If your income is zero and you qualify for the VA pension, you will get $1,100 a month. It takes all other sources of income into account in capping you at $1,100. If you receive Social Security and you get $1,200 in Social Security and you're eligible for this, you will get $0. You will still be considered eligible, but you will get no money. Veteran has to apply. There's a basic form they have to fill out to show that they're disabled and otherwise qualified based on D214, and then they start through the same process as service-connected claims. Typically, what veteran service officers do is they have them fill out the same piece of paper for both just to see if they're eligible for both, because typically service-connected claims are harder to prove than VA pension. VA pension is kind of clear, stops of eligibility. The usual hang-up on that is, was your disability paperwork, current disability paperwork good enough, and do you have enough proof of income? But this is really what I'm talking about, it, which is the important stuff for older and retired veterans. It's a supplemental program called Aid and Attendance. This is relatively new, which is the need-based pension walks back your income for your out-of-pocket medical expenses. So what that means is if you get $2,000 a month and you are in a nursing home that costs $2,500 a month, the VA says you have negative $500 in income and kicks in the difference. This is true for any veteran that's eligible for, is bedridden or is in nursing care or has significant help that they need from outside people, even if it's in their daily needs. The formula for this is so complicated I would never show it to anybody without giving them a headache. But this is important to remember when you're talking about low income or not eligible, or people that say, I make too much money or I'm not eligible for anything. This is open to a broader swath of veterans than most other benefits, and the income is determinative on what your out-of-pocket medical expenses are. So if you're paying a lot for home health care, home health aid, or if you're eligible for going for nursing care, what you can afford could be tremendously affected by this. Fortunately, for the nursing care, most nursing homes are aware of this, so they scoop up veterans and apply for them. But for veterans that don't know about it, this is also eligible for spouses of veterans, including living veterans, so they don't have to be deceased. So if the spouse needs nursing care, the veteran could still apply for this to help pay for that. So this is a much broader benefit that's available to veterans than most of what we're going to talk about as far as cash comes. And this benefit caps out at about $8,000 a month, so it can get very generous. You can have significant in-home health care needs that will be paid for entirely by the VA and only have 90 days of service and 1 day of wartime service to be eligible for that. So this is something to keep in the back of your head when you are talking to veterans that are struggling financially, but they're not on the street struggling. They're struggling with health and with home health needs or nursing care needs. And if they are a veteran, this is the one to keep in the back of your mind. Wartime veteran, you have more than 90 days service, were honorably discharged, that this may apply to them. And this is not well known, or as well known as should be, considering how many people are eligible for it. We catch people all the time that are eligible for this that just don't know it exists, never applied for it. Okay, moving on for the VA pension. Is my JAG gallery happy with that? Did I pass? Okay. We're going to talk about the service-connected pension. I'm just doing a time check real quick. So, okay. So the service-connected pension is the big legal problem. This is where almost all of the pages of legal work done on VA benefit stuff falls into. What a service-connected pension is a veteran that something happened in service that is still negatively affecting their day-to-day life in some medical way. It could also be an aggravation of something they had when they went into service that is worse now than when they entered. When they apply for service-connected disability, what they're going to show is they're going to show that by their medical records, something occurred to them in the military service that is now a current disability, and that according to a doctor, what happened in the military service and what's now affecting them are connected. Those are the three elements they have to show, and this is where everybody's going to get caught up in one of those three things. The nexus has to be the medical opinion of a doctor. So what we see frequently, or where the problems are, to think about this is not the combat wounded veterans that have problems with this. It is people that have something that's similar to workers' comp claim or personal injury or tort, where they were basically injured on the job, and now down the road that is causing them problems. The doctor has to determine that your current disability is disabling to some extent, and then connect it to something in military service. Where this becomes a problem is there's obviously frequently a large gap between when they apply and when they got out of the service. So our typical veteran that comes in to see us is in their 50s or older, so their military service is 30-something years old, and what they're looking for, what the issue is, they need to get a doctor to say something that happened 30 years ago is the cause of your current disability. That's where the most frequent legal problem we have is trying to get the VA to accept that currently you're being affected by something that occurred decades ago. The less time between the application and the discharge, of course, there's less time to fill in the gap or fill in that blank. Your rating scale, how it works is there is percentages assigned to us. So if you've heard the word 100% disabled veteran, the percentage is because the VA gives ratings for how bad your disability is. So the common refrain from the idea of disabled veteran is somebody that is, physically disabled or somehow disabled in a way that manifests itself obviously. But the VA definition is a lot broader than that, because 0% or 10% can be disabilities that you would never know somebody has, or it wouldn't come up in the normal course of conversation or interacting with them. So 100% disabled means you're eligible for the maximum amount of money, which is $3,000 and a little bit more a month. 10% will get you $137, something in that range, a month. And then the percentages in between fill it up. It goes by 10% increments, so nobody is 65% disabled. And the VA doesn't do math like normal people does, so 30% plus 30% is not 60%. It is something different, and that depends on where your 30% is coming from and how they interact with each other. But you can have a combination of conditions that can eventually add up to 100%. The most frequent issue we see with this is that people are upset with their percentage amounts. The gap between 90 and 100%, unfortunately, is $1,900 to $3,000. So you'll never meet a 90% disabled veteran because they're always going to go for more because that seems like a huge money gap. But that is common issues. They're upset with their rating percentage, and what they're going to have to show the VA is that their current disability is more severe than the rater thought it was when they gave them the percentages. Showing service connection, VA, the military kept terrible records. I don't know if that's gotten any better. Veterans don't keep their own records. Everything's lost in a flood or a fire. The service records didn't include everything they needed to. There's a lot of stuff that just goes unreported or doesn't make it in your record or went to battalion and never made it in your personnel file. There's always a challenge involved in proving stuff that happened a long time ago with official paperwork. Service-connected disability does not mean you are disabled under the usual definition. It doesn't mean you're disabled for other purposes like Social Security. You can be a 100% disabled veteran on service connection and be ineligible for Social Security disability. 10% can mean relatively minor problems like tinnitus or hearing loss. 0% rating is possible. It means you don't get any money, but the VA has said this is our fault, so if it gets worse, we'll pay for it. And the compensation is for the disability after treatment. So this is particularly a problem in mental health issues. If you've been prescribed something and you don't take it, you don't get paid on how bad you are. You get paid on how bad they think you would be if you followed your doctor's orders. Initial application process for a veteran is shockingly a 2-page form that will very rarely get approved. And attorneys organizations cannot charge to assist with it. They try to keep attorneys away from them at the initial application stage. The date that the application is received is the first date for which they can be compensated. So I have the formula up here. Basically, the way it works out is the VA won't compensate you until you tell them to pay me. So if you get a disabling condition in the year 2000, you applied in 2010, and you get approved in 2015, they will pay you for those 5 years. If you got a disabling condition in 2015 and you apply in 2015, you will get your full back pay. Of course, this is the exception. Most veterans will have gone back further. If you've applied and you were denied and then you didn't follow up with that or didn't appeal, and you apply again at a later date and that gets approved, they will go back to your approved application, not to your initial application. So if there's a gap between the two, they won't go back that far. Congress can fix this, they won't, but it is wouldn't apply in any other situation to where there's a cutoff date where you have to apply for your disability. And if they did that, they would be opening a can of worms for how far back they have to go for some veterans. The process takes a long time. The traditional process takes a long time because the VA is responsible for gathering all of the evidence. This is where the absurdity of the program works out when you compare it. As I said, think about it like a tort or workers' comp. In this case, you have a tort case, and your attorney works for the VA, and their attorney works for the VA, and the judge works for the VA, and your doctor works for the VA, and your record keeper works for the VA, and you get a piece of paper back that says no, and you think, well, darn it, I'm pretty sure there was some conspiracy going on here because all of y'all were on the same team. And this is one of the fundamental problems of the system is that the VA is supposed to help the veteran. They're supposed to take them at their word. They're supposed to find the evidence for them. They're supposed to put the case together for them. In theory, all the veteran needs to do is say, I'm disabled, and the VA says, well, take it from here. We've got your service record, we've got your medical records, we're going to put them together, see how it was our fault, and then we're going to make a fair decision on how much money we should give. In reality, that doesn't work. And that is where the frequency of the problem comes from. Now, I personally don't think that the VA compensation section and the doctors and the medical section, only overlapping reporting is at the Secretary of the VA level, and they split down after that. Though they're not working together to make this difficult. But if you're the veteran and your doctor and your judge and your advocate all work for the same people, it's pretty easy to think that there's some shenanigans going on here when you get denied. The custodian of the records is one of the big problems because if you apply, the VA has to find all of your records and gather them together. It creates a huge stack of stuff. And the theory is that the claims review officer is going to read your 1,000 pages of medical records and 200 pages of service records and figure out what went wrong. The reality is that nobody reads 1,000 pages of medical records. So that's where the mistakes frequently come up. And the veteran doesn't know why they were denied because at no point in this process did they see all their own paperwork. Right? The VA was custodian all the records. They said, we got your medical records, we got your service records. We've decided no. Well, if the veteran doesn't know what's in the records, how do they know whether they made the right decision or not?
So the veteran doesn't have access to his own records?
They can get them and they should, but
Do they have to subpoena them?
no. You're entitled to your own medical records. You're entitled to every piece of paper the VA has on you. But reality, unless they have a lawyer that's telling them to do it, or another advocate that's saying, get all your own stuff, You have to do your own case. The VA won't do it for you. I know they say they will, but they won't. They don't do it. And they also don't want to read their own 1,000 pages of medical records, because who wants to read 1,000 pages of medical records? I've read 1,000 pages of medical records. I don't want to do it either. But they don't know what's in it, and that's why they don't really understand why they were denied. And that's why they come into our clinic. They show it to a lawyer and say, I don't understand why I was denied. Well, they've not seen their own medical records, they've not seen their own service records. They lived it, they experienced it, they know it, but they don't know what's in the paperwork. Yes?
Well, let me give you a little war story. It's just bigger than just a war story. And ask you whether it's been your experience that the times have changed. And this is way back from active duty as a J, but what used to happen with great regularity is the concept was when you're in the military, you're on duty 24/7. And literally you can be called 24/7. And so if you're driving your automobile on a Saturday or a Sunday, and you're in an automobile accident, and you're injured in an automobile accident, you're not really doing the course and scope as we would think of it in workers' comp and employment, but under the 24-hour umbrella. And as a result, you have to have some surgery on your back. So you have some surgery on your back in the military hospital. You got good records of it. And it doesn't mean they have to kick you out of the service. It does not impede your performance, but it does impede somewhat of your discomfort. And the VA would say that is worth a certain percentage of disability. So what would happen when people would separate from the military service and start drawing their retirement pay many years later after that so-called under the umbrella of 24 hours, they would take those medical records, give it to the VA, and they would get a certain percentage of disability, just routinely. Now, you ask yourself, why the heck would they do that? Well, the reason they do that, and you probably can get this in the presentation, is the VA disability is tax-free. So what happens is if you're, and this usually happened with general officers, quite frankly, because I've represented a bunch of them over the years, and you know, what they would do is they'd say, I'm going to get X dollars a month for the rest of my life after I retire at 20 years or 35 years or whatever it is. But I can get 10%, 20, 30% of that tax-free for the rest of my life if I get the VA disability. So there was a real nexus between the active duty and the VA systems that would facilitate taking those active duty medical records. You go to retirement, they take them down to the VA facility, and you get the VA on board, and you get the communications between the military doctors and the VA doctors. So my question with that, because I saw that happen with great regularity, does that still go on, or do you know?
You work with general officers, they do a much better job of tracking their own paperwork. I mean, that's the big difference, is that they just document everything, they know what's available to them, and they prepare, especially for retirees. And it was just a reality of military services, very physical labor. If you work any physical job for 20-something years, you're going to get, something's going to go wrong. So most people that should retire should be getting some disability compensation. It is tax-free, it's more than tax-free. It is also unattachable by any creditors. It is also reduced from your property taxes. It also entitles you to free toll tags and all kinds of other stuff. So there's a lot of value in being disabled.
And I don't think it counts for income for child support either.
It does count for income for child support.
Disability? Because there's an exception for one kind of veteran.
The VA pension does not count.
Okay, that's what I was
The service-connected disability does count
Okay.
for purposes of child support. Glad you answered that. That's one of the most important things. My entire reason for existence is because I know the answer to that question. I answer it all the time. I'm the only one that does family law and VA stuff. Yes, it counts. It counts for that, for spousal support. For service-connected disability does. VA pension does not. However, like Social Security, the VA pension will pay you to pay your child support. Will pay your child support for you at the lower level. So if you get a VA pension and you have a child support obligation, they will, in theory, step in. This is a very taught process in reality. Now they do a better job of getting people out the door. Apply for it on your way out the door, even if you don't think you're disabled.
Other than just the general officers.
They're trying to get everybody now. And that's just reality of it. I mean, a lot of the backlog just has to do with that. It's that they're just doing a better job of catching people, which means everybody's in the system, right? And they have, a high ratio of people getting out and people applying at the same time. It's because it's a broad definition of disabled. Again, it's not the I can get disabled tag on my car. It's not I need a wheelchair. It's I can't hear. So it's worth applying for anyone. And again, tax-free money, other benefits that come with it. If you get to 100%, you don't have to pay property taxes. I wish I could do that.
Well, the big enigma to me at that time of my life was always that it didn't, we put it under the umbrella of 24-hour service, but it really wasn't like you fell off the tank It was like you were in an automobile accident on
Yeah.
a Saturday or Sunday and you were injured.
And as
because
long as
of
it's
that,
not
compensation.
the result of
That's
misconduct of the veteran, that is strictly his fault.
That's right.
We see those hang-up cases as well, right? They got in the accident and they also got DUI for the same incident. That VA has nothing to do with it. They won't give you a penny for it.
I have a question about that. What about reckless driving? Would that be misconduct?
That would be why lawyers exist, right? It was reckless, but it wasn't that reckless.
No helmet on a motorcycle at night. Reckless.
I don't think there's going to be a clear-cut rule on that. I could be wrong, but that's one of those where you bury your head in the CFR and see if anybody's argued it successfully or unsuccessfully. That's a case-by-case basis. The willful misconduct is generally a pretty high threshold to cross. So I have seen the, messing around with the buffer in the stairwell type injuries where they definitely shouldn't have been doing it, but, it wasn't so ridiculous or so horrible that it was, going to cause someone to get seriously injured. I saw another hand in there. Okay. So the appeals process also looks like nothing else you'll see in any other area of the law. It is very generous. You have a full year to appeal. The appeals can be handled by a VSO, an attorney, personal representative, so somebody that wants to help attorneys. And there's now 3 routes for appeals. This is new as of September 2017, so if there's anything in this that's wrong, it's because it's changed since then. I mean, this is the new one as far as I understand it, but I've not seen it in practice yet on them actually separating these things out where they've told me what lane it's in. It still just looks like it's in the same place. But your appeal, you can either say, I think the first person that looked at it made a mistake, I want somebody else to look at it, the exact same thing. Your appeal can say, when I applied, I had some evidence, but now I have different and new evidence, so I want my same claim looked at, considering the new evidence. And I want to go straight from the regional office here in Houston and appeal to the board. That there's a traveling board for this region that operates out of DC, and they come and they travel around and do hearings. So you want to go above the claims reviewer. You want to go to the people that have been doing this for decades and make a lot more money. So you now have your choice of which appeal route you want to take. The idea is to separate out the ones that are looking for a different answer to get faster. So your new evidence claim is supposed to get fastest review, and if you want to go to the board like everybody would have before, you'll still have that long delay. Why does it take so long? Well, when it gets to a claims review officer, first thing they have to do is gather all of your records. So this involves them sending out requests to a bunch of different places, anywhere you've received medical services from the VA or the military, anywhere your military records may sit, and gather everything together. Once they have it all, they're supposed to look it over. Like I said, they're supposed to read your 1,000 pages of medical records. And then they issue the decision. They have a year to appeal. That entire process in itself will take a long time. Once they go to the appeals process, this was not produced by me, they start adding up those days. And the average for an appeal that was approved in 2015, I think the data was from, the average of an appeal that was approved at the board level was 1,500 something days. That would be the average.
Does this go, does this survive death? So
Yes.
if they die in the process, your heirs can keep
Their
after?
heirs can get it, yeah.
Okay.
And actually, if part of it can be proved separately than the claim, the spouse can actually start receiving death indemnity compensation while that claim's still pending. So they can actually, which is faster and easier to get than the disability appeal. So, I mean, the fastest way to get benefits is to die, but that's not how it works. So for people, what can be done about the delays? Well, they've changed some of the laws. I don't know anyone in the industry that feels like there's going to be a significant change to that 1,500-day waiting process. Sir?
That's what I was thinking of. The White House said that they were going to make changes, or have there been any changes? And if not, do you anticipate a bunch of changes?
This is new. This is new. This is 2017. December 2017 is when it effect. Everything used to go to the board lane. Now we're getting a chance to have just specific parts of it reviewed locally if you just think they made a mistake or an error. So this is something I see pretty regularly where they make just a mistake of fact, like they got you on the wrong ship, like something like that, where normally you'd have to go through that 500-day process to get that fixed. Now they've given you another alternative. Whether that's actually going to work any faster, nobody I know has actually seen that happen yet, right? It still feels the same. So we'll see.
if you chose one of the two newer options, would that preclude you from doing another?
No, because they all, you can do one at a time, but they all pile upon each other, right?
Right.
So I have an example of this where my father had diabetes as a service-connected disability, and he was at a 90% rating, and then they changed his rating to 70% because they claimed his diabetes was cured. And it was it's type 1 diabetes, which is incurable. And so he's been waiting on his appeal for about 5 years. And so
this is just when it gets out of the VA system. After this, you can go to federal court. So you can add another decade to this on federal court appeals. So what Paul's talking about, and I don't have it part of the presentation because it's complicated, your disability compensation is for your current disability. If they give you a percentage in the future, they can re-examine you and decide to give you a lower percentage. This I have noticed is a big change in the last 2 or 3 years, where I, in the past, never encountered people that were older that were getting those reviews done, and now I see it all the time. So what those reviews do is they send you to a doctor that works for the VA that gives the VA reasons to lower your rating. They're supposed to compensate you for your current disability, not your past disability. So if they say you've gotten better, they will give you less money. This is the worst part of what the VA does because it creates what I call it the negative financial incentive to get better, right? This is the only time I'll mention post-traumatic stress disorder in this presentation. If you have post-traumatic stress disorder and the VA is giving you 100% disability at $3,000 a month and you get better, they will pay you less money. So congratulations on getting better. Now you're not getting your bills paid. So this creates a negative incentive for people to stay sick and to keep their records as grave as possible in a way that is giving them a reason to not be as 100% honest as they should be. And the more they review these claims after they're older, after people get older, the more incentive they'll do to do this. Because the reality is, if you've been a disabled veteran for an extended period of time, you are a terrible person to get in the job market because you have a huge gap in your resume. You have, according to you, still significant disabilities, and you have no way of substituting that kind of tax-free income. So $3,000 a month in tax-free income in the real world is $50,000 more a year. So I mean, it's a pretty good job equivalent of pay that if the VA decides you've gotten better medically, they will cut off with very little notice.
And there's no independent review by the VA to check on these veterans to see if in fact they are improving or they're following the medication
So
regime.
what they do is they send what's called a compensation pension exam. So you get a letter in the mail at your address on record that says, within the next 90 days, this is the date and time you must appeal at this. You must appear at this doctor, and you cannot miss this. You can reschedule it, but you can't miss it. If you don't show up, they'll cut you off. If you show up, what the doctor's there to do is give the VA reasons to reduce your compensation claim. So a lot of veterans that do show up don't know that this is why they're there, right? And this is what happens with people in general, particularly the people that the VA generally serves, which is old men, which is, I'm fine. Well, if you tell them you're fine, you're going to get a letter a few weeks after that says we're reducing your 70% to 30%.
Congratulations, you're fine.
Yeah, congratulations, you're fine. Good job on getting better. We're taking money away. So the entire incentive structure on that is just terrible, and it creates unfair situations like Paul was describing, where you get this absurd idea that what your disability was that has unchanged in the last few years is now all of a sudden less severe or has gotten better. In some cases that does make sense, but those are also difficult situations for veterans that are going through mental health or other issues where all of a sudden the VA says, congratulations, you're better.
We're about out of time.
I know, I did not even make it to my second one. Go ahead.
Oh, you didn't.
That's fine.
We had lots of questions tonight.
I know we did. Well, I'm glad to have an engaged audience. Is there anything else I'll be very terrible if I don't tell you all about? I'll feel terrible about all this stuff. We're going to talk about pro bono for 1 minute.
Yeah.
What we actually see at our clinic are these legal issues. This is what people, after 18,000 something people have come through our door, have told us they need help with. Family law, estate planning, other financial issues, landlord-tenant, VA benefits at the bottom. If all of this was confusing to you and you still want to volunteer, good news. If you do any of this stuff, you'll be very helpful. Even if you don't, most of what we see are people asking questions that if they wouldn't bring to you, they would be bringing to Google or they would be bringing to their cousin. You are better than Google or their cousin. That is what we're doing. We're talking to veterans and giving them general advice with what they bring to us so that when they leave here, they have a better understanding of their own legal issue. Skip. We're going to be out here in Tomball on October 20th, and then if some of y'all are closer to Conroe, on November 17th. What we do there is we run clinics where veterans come in. You're going to talk to them one-on-one, give them the best advice you can, give us information on their case, and then if they qualify financially, qualifying legal issues, we at Houston Volunteer Lawyers will try to get them a pro bono attorney. So all you have to do is sit there, listen to their story, give them advice, and tell us what you think we should do with the case. That is all we're asking you to commit to. It is 3 hours on Saturday morning from 9 a.m. till noon. Really should have included that. And that's my contact information.
And they give you nifty books with all of like the basic law frames. So if you get a question on an area of law that you don't know about, they have a reference material for you. So I would highly encourage it. It was very rewarding when I did it. Any more questions? I know I'm trying to keep us, we're a couple minutes over.
Sorry.
The question I was asking earlier, have there been any substantial changes in your opinion from the White House, or do you think there will be, or just be some minor stuff?
I haven't seen it. I wouldn't have expected to see it yet. They've changed something else as well, which unfortunately I had to skip over, which is that they've changed the way you can apply for an initial application. So it doesn't go in the same pile, but just says review my rating or something like that. That is more recent. That's 2018. I've not seen a claim on that yet, but that's supposed to be in under 30 days. So I will see if that works probably some point before the end of the year. But that was the other big change. Most of the changes in the law were not stuff that affected the stuff I talked about. Or it's been stuff that's been in Congress multiple times and has passed the House multiple times, and it was just kind of waiting to happen.
You don't think there's going to be a major overhaul?
No, because I think most of what's happening is you're seeing a bottleneck at one level that they cleared by making quick and bad decisions and to move the bottleneck to the next level. So they can say we've only got, we've gotten rid of 90% of the backlog, and at some point they're just going to move the backlog to the federal court, and then it won't be their problem anymore. Because I'm just seeing a huge uptick in bad decisions over the last few years. I don't think that had anything to do with new laws that passed. I just think it had to do with pressure for them to clear cases out faster. So they're just making mistakes. They're missing stuff that's in the record that's clear. It's not the stuff I was seeing a lot a few years ago that I've just started seeing a lot of now.
I just wanted to ask you, this is the federal government, you're asking to be efficient.
But there's been a lot of talk about it, though.
Oh, there has been, right.
More than I've
They talk
heard
about a lot
about.
of things, don't they?
Well, Andrew, obviously we very much enjoyed having you come. This was probably the most interactive group for this particular topic than I have been a party to in a long time. So we really appreciate you coming. I'm sorry we ran a little short on time.
Sorry.
We'd like to give you a small token of our appreciation, and we'd love to have you back maybe next year if there's change in law or something like that. We'd love to have you back.
Yeah.